there, and there's this dog looking up at him, and the attorney in like quotes says, you know, I just want to let you know that walk I took with you, I could have billed out $175. And the dog's looking up at him, and it says in quotes, I just want you to know I'm your only friend. So just bear with us as we go forward here.
And Tara, can I just tell them that I did already give you guys a copy of those Montana laws, and Tara informed me today they've been updated. So, but she'll kind of just let you know.
Yeah, I'll try to point out. So the way our legislature works, which most of you probably know, is that a lot of laws don't go into effect until October 1st. And so we just, this week is the first week, we're really complying by them. So I went and updated my presentation. At first I thought, well, you guys don't need to know. This will just be the law as you know it, and you won't have to worry about what happened before. But given the fact that you have the older statutes, I'll try to say, okay, here's the difference between what happened then and what's happening now.
So the presentation is the current.
Correct.
Okay.
It is. And there's only like some few real substantial changes. It's not too many, but when I say substantial, they kind of change the way we're doing things. And so that kind of puts a slight hiccup in everything. And I think everyone will be somewhat slow to kind of come around. But all of you will probably, I'm assuming, get assigned to cases after today, since you're still going through training. So you won't have to worry about the old law unless someone decides to jump ship on a case, and then you step in, and then, I don't know what to tell you, but we'll work through it. I also talk really, really fast. And part of that is I've been going a million miles an hour all day, and now it's 5:30, and I'll be here for 2 hours. So if you need me to slow down, just say stop, take a breath. I didn't get that, and I'll try and slow down a little bit. All right, so the very exciting, I tried to do mountains, you know, I thought maybe that would make us feel like we're not just learning the law. I think one of the things that's important to remember when we're doing these cases is what the policy in the state of Montana is. I think a lot of people, and I shouldn't say a lot of people, but a lot of the parents and families we deal with, and maybe even some of the attorneys, feel that it's CPS's job just to go steal children. Right, they have nothing better to do in their lives, you know, they just want to go in there, and if they see a dirty house, then by God, they're going to take that kid out of there, and you're never going to see your child again. And as much as I love stealing kids, right, I have them all hoarded in my basement, we have better things to do. We all have enough work. They don't get paid enough to be taking the kids home, let alone we don't have enough foster homes to put kids in, even if we are taking them out. So it's important to remember what the policy is, and in the majority of cases, we are always working towards reunification. So we're trying to solve whatever immediate problem occurred in which we had to remove that particular child or the children from that family, and hopefully we can make it safe for them to return to that house. So that being said, the policy is actually statutory. So you should be able to find this in your statutes. It sets forth what the policy is, so it's more of a directive. It's not, I think you guys have you already had the presentation by the department, Dennis and Mark? So they have their own set of policies, which is voluminous, to say the least. I have not read every one of them. I will gladly tell you that, but I'm not, although I do department cases, I'm not a department attorney, if that makes sense, so I don't have to read them all. I have too much other things to do. So. Number one and the foremost is to provide protection of the children. So whenever we are trying to make a determination, does that child need to be removed? Can that child stay in the home? What should we do with the case if we've had to file? If there's some type of formal versus informal? We're trying to determine, is that child safe in that home? And what do we need to do to make sure that that safety will stay there? Is it a situation where we can put some kind of informal agreement in place, which then you don't have to worry about because you don't get triggered and involved until we actually file. Second, preserve the unity and welfare of the family. So this goes really to the reunification piece, that our goal is to put children back with families. I just had a defense attorney in my office yesterday, and he hasn't done a lot of the department cases yet, which is always fun. And so he pretty much thinks we're just stealing children. And he's sitting there telling me, you know, Tara, you're just going to terminate. He's never going to see his child again. And I'm like, are you freaking kidding me? I'm like, no, that is not the point. You know, if I wanted to terminate, I would have filed a petition to terminate from the beginning. You know, he needs to do the stuff he needs to do. He needs to do the treatment plan, get it together, sign it. And the faster he does it, the sooner he's going to get his child back. But if he decides not to do anything and you are sharing this attitude with him, which he apparently has too, it's probably not going to work out very well. And then you're right, maybe I will end up terminating. But not our goal. So third, ensure no forced removal of child without reasonable cause to suspect, child is at imminent risk of harm. And this goes back to the fact that we are not just going to be taking kids for no reason, right? There has to be a safety issue that we're concerned about in order to remove that child. So there may be times before you guys are ever even involved where we have, well, there are plenty of times where we have cases where we work on a voluntary basis, and they're trying to get services into the home and people into that house that we don't have to remove the child. Most of the time when we file cases in our county, we've done a removal. There are a few limited minority cases where we actually leave the child in the home and we file, but those are the exception rather than the rule. I have too many things to do to be filing cases.
If you left the child in the home, what do you file for?
So at that time you can file, we usually still file for temporary investigative authority, which I'll talk a little bit about, but that allows us to investigate the case for 90 days. I usually also file for temporary legal custody, so we still will take custody of that child, but we'll just keep them in the home. And then what that does to the judge is it says, okay, if you need to remove at some point later on, we'll provide the court with notice, like this just fell through, this isn't working, and we give notice to the court that we did actually have to do a removal. But most often we remove, so it's the minority. The ones we do, I would say temporary investigative authority, like you can file a petition just for temporary investigative authority, and if we're just doing TIA, we rarely remove on just a TIA petition.
Okay.
And so by the time you get to that step, somebody has already made the determination that the child is at imminent risk of harm.
Correct.
Right.
The time we remove, they better have decided that. They haven't, then we're getting the kids back as soon as we can. We're just like, all right, well, sorry about that. Wrong house. All right, fourth, recognize the child is entitled to assert child's constitutional rights. This is actually, so there is a change that I'll talk about when I get to who is represented and who the attorneys represent as far as parties. But the child does get an attorney. Prior to October 1st, the child is required to have an attorney appointed, and now, depending upon whether or not there's a CASA and a GAL, which in every case, a GAL is assigned, which you're the guardian ad litem. You're the GAL, the CASA is in our jurisdiction. If you are assigned, now the new law says that an attorney is not required for every youth, but it's when appropriate, the court may appoint it. So that's something we're going to have to try to work through as a jurisdiction.
Case by case basis,
And
then.
and try to decide.
Has there been discussion about what's going to happen?
Well, there has. So the public defender system in the state of Montana, parents aren't required to pay for an attorney, and the child is not. Obviously, the child's going to get money, especially parents aren't going to give the kid money, right?
Put them to work.
Yeah, right. There you go. Got some dishes. I got a lawn that needs to be mowed. But they right now it comes out of their budget. So all the attorneys are assigned by the public defender's office. The only one that comes out of the county budget is, I guess, me. I am trying to actively recruit another person to help me out so that I'm not I'm a little insane and crazy right now. So that might come through my naiveness that I started out with. I'm jaded and I might be going to cynical, so you got to bear with me there too. And I just sat through a week of child sexual abuse and every horrible thing that happens to a child last week training in Denver, so I'm recovering from that too. So just with that, I should have started with that, right? Like the caveats and the bewares. So I'll try to keep my humor tame for this crowd. But to answer your question, Bill, it's like got sidetracked there. They're talking about when a child, like perhaps at infancy, like a year or 2 years, when they can't really speak and assert what they want. Carolyn, and who does she used to do these cases before me, and she was fabulous. So now she represents kids in the public defender's office, contracts with her. And then there's another person in our jurisdiction, Helen, that will take conflict cases. So those are the two primary child attorneys. They've been discussing with the public defender system of not appointing in cases where it's an infant or a child that's non-commutative, so that if it's an older child, then they can represent their wishes, but if it's a baby, they kind of think maybe they're just wasting time. I personally like having Carolyn sitting next to me, so I'm kind of like, well, I don't know. We'll see how that goes. But I do understand the, trying to save money, and in reality, a 6-month-old can't tell you what he or she wants.
So you said you personally like to have an attorney sitting next to you, is that what you said?
I just like Carolyn sitting next to
Oh,
me.
Carolyn, okay.
Sorry,
Carolyn.
not any attorney, just no. Most of the rest of them I can do without. She was my mentor, and so it's always kind of nice. Like if I miss anything, I know she'll get it, or it's just one of those things where it's kind of like a blanket that you have that you just want to carry around with you forever, right? So, but she's trying to run away from you as fast as possible. The next is the right of the child to healthy and safe childhood. I think this goes somewhat with the protection. It's just another aspect that all children in Montana should be able to be safe in their homes and healthy. We don't have to worry about failure to thrive. They should be able to eat and have the basic necessities provided to them. So, and psychological well-being. And then the final one that's set forth in the statute is to maintain ethnic, cultural, and religious heritage whenever possible. I think this one, more than any of them, becomes a constant struggle in our state because, frankly, there aren't a lot of minorities around. And so when you look at the foster care, if you're removing a child depending upon whatever their ethnic or cultural background is, or even religious background, to try to make sure that you're moving the child into a similar background is really difficult. The feds obviously mandate when it comes to Native Americans. We have the Indian Child Welfare Act, and I think you have a long section on that you will. Have you done that yet, or you're going to?
No, do it Thursday.
Okay, well that'll be fun for you. So that's the feds basically telling us that we're going to treat Native American children differently, and we have different standards for them. They're higher standards. Which you can agree or disagree with, but that's the way that it's set forth. And so other than Native Americans, there aren't any other, there's no other culturally sensitive mandates, I guess to say, other than we're trying to do the best that we can. I think that, I don't know, I say it's a constant struggle because I think it's a constant struggle. It really depends upon if you're going to get lucky and who the foster parents are and whether or not they're willing to respect that and what those boundaries are. I've found that when you're placing Native American children in non-Native families, if they're looking towards adopting them, the majority of them are very respectful of that culture and try to take them to the powwows of their tribe and get them to know that information. The more or better luck we have with it is when we can find someone in the family to place with, so we're not placing, we're doing kinship care rather than placing with strangers. So anyway, we're still struggling, but we work on it. So just be aware of that.
Kara,
Yeah.
does that involve kinship care outside of Helena?
Correct.
Or do they have to be in Helena?
Nope, they don't have to be in
They
Illinois.
don't have, so the child can be actually go someplace else?
Yes. If it's if we're looking at a different state, then we usually have to do some type of a home study prior to that child being placed. If it's within the state, then we have to make sure we at least do background checks and that they're approved. But if it's someone in Missoula or Billings, that is a potential placement.
How does that affect a school-age child and pulling them out of school and putting them in a new school? I mean, we must factor that in. Or does ICWA pretty much just override that?
Oh, well, so I would say regardless of whether it's ICWA or non-ICWA, that should be factored in. I hope it's being considered. We usually, especially during the middle of school, if we're looking at moving kids, is there a break that we can move them on? If they're going to be pulled out and taken away from everything they know, then we'll try to see if, maybe there's a foster placement where we can keep them here if that's better for them. So it's really what ends up being in their best interests, and I think that each of you will play a huge role in that, in determining whether or not is it more important that they go and live at Grandma's house in Billings and try to reestablish themselves, or if it looks like we're going to eventually reunite if we keep them local.
Better to stay here.
Yeah, and I think a lot of that comes down to probably the long-term plan. So we'll have.
The age of the child too.
I would say that too, but if we're looking at we're going to have to terminate and the parent isn't doing anything, then we're always trying to find a permanent placement. And the preference is always family, and the policy at the department is the preference is family. but there are those struggles, so you have to kind of balance it and take it by case basis.
I have a question on the back.
Sure. Yeah.
It's, how wide is it? In other words, if you were taking a child and sending him to grandma or grandma and grandpa, is the background check just on grandma and grandpa, or does it maybe include two uncles or drug dealers who might be stopping by the house?
Well, okay, first of all, are they telling you the truth? I usually learn no, but that's me being cynical. So, they do background checks on anyone that's living in the home, which is different than maybe just uncles occasionally stopping by.
That's kind of what I thought you were going to say.
Yeah.
Okay.
So, most of the time, frankly, this sounds bad. Maybe I shouldn't say that.
Say it.
I hope people tell us the truth. I don't believe that they do.
They probably don't.
I think that if they want the child back up, they're not going to tell you Uncle Joe is, convicted of some kind of felony or registered sex offender or whatever the heck is going on there. So,
Okay.
but it's the people that we know to be living in the house. Now, if we later find out information that they didn't disclose, then that doesn't work out very well for them as far as placement of that child.
Okay.
It does include CPS history, so Child Protection Services history, and also criminal background. So as far as wide, you're looking at kind of two different areas. All right. So key terms, and my mock code, Ann, is just, I think you guys have like a big packet of statutes.
Mm-hmm.
So it's Montana Code Annotated, which I'm sure some of you know. All the statutes are set. Title 41 sets forth most of the youth stuff, and so then in Section 3 we have the youth in need of care cases. So there are tons of key terms. I'm not going to tell you every term. We would be here until tomorrow, and I'd probably be past that on the floor, and you guys would want to stab me or something. So let's just do with some of the ones that are most important to you. One, best interest of the child. That's really your goal as a GAL and as CASA, is to determine what is in the best interest of the child. So fortunately, the legislature doesn't just allow you to decide what that is. They give you some definition. It may not be as specific as you want, but means physical, mental, and psychological conditions and needs of the child. So whatever you determine that to mean, and in consultation with Bill, he's a great source, and he's been around for a little while, so he's seen a lot. So he usually knows what is in their best interest. And when we disagree, then I'm like, oh, what am I missing here? This isn't good. I don't ever want to be on the other side of Bill in the courtroom, so I'm usually like, all right, well, maybe we should put the kids back in the house, and then maybe I'm not seeing this the right way. Because Bill usually wins. So child abuse or neglect definition. So when we're looking at the department and when they get involved, if we're taking it to the point where we're filing, we're making a determination that that child is what we call a youth in need of care, abbreviated as YNC. Youth in need of care, in order to establish that, we have to show, you gotta love this, definition after definition, right? Keeps all the lawyers employed, because no one can understand what it means. So we just decide to continue our unemployment. It works out well. But youth in need of care means that the child has been abused or neglected. So when you look at that, you have to, okay, so I know if it's a youth in need of care that I have to have child abuse or neglect, so what is the definition of that? And we have three different options. One, that there's actual physical or psychological harm to a child. So those are, some pretty simple. You leave marks on a child. Depending upon where you've left marks, there's physical bruising, psychological harm. We've had cases. Do you want me to sugarcoat this, or do you want me to? Because I can.
No.
All right. You want to know what you're getting into before you totally finish this class, right? Okay. So we've had cases where mom, for instance, is talking about how she's going to kill herself in front of the children, and that this is how she's going to do it and planning it, and that part of the reason is because of them. There's some, so there would be obviously some concerns about psychological abuse and damage happening to those children. Other cases where you have torture, so you'll have more than just psychological. You have the psychological damage. You'll have the physical itself. We had a mother who picked up a transient because the babysitting's free, and sorry. These things I have to find some humor in, so when I'm laughing inappropriately.
Don't worry about it.
But, so, she had multiple kids in her home, and ends up coming out that while he's babysitting, he's giving them like cold water baths and making them lick urine and eat their feces and, like all kinds of horrible things and physically abusing them. Obviously you have the psychological as well as the physical. And even though it's not mom that's doing it, mom's allowing for that to happen. So she's just as much responsible, at least from the department standpoint. Second, substantial risk of physical or psychological harm to a child. For instance, you have a case where, and I'll just say male because more often than not it's males that we charge. There are female offenders. But you find out that stepdad or boyfriend that lives in the home has been sexually abusing one of the children. Mom has been aware of it, is refusing to believe that child. And so you have a case where boyfriend isn't biologically related or stepfather isn't biologically related, but mom is. Father, of course, of the child is nowhere to be seen, just MIA. And so then you have the situation of what damage is it going to be depending upon what mom's position is for the child. So if the mom decides to stay with the offender, obviously we're not going to let the child stay in that home. We had a case that was probably, in my mind, one of the worst things that happened, and I don't ever want to relive it, but where mom kicked the offender out, but then did everything she could to get the child to recant because it didn't happen. And so that was somewhat of a nightmare, and that ended up getting finally called in by a therapist as risk of substantial psychological harm to her. So the final one is abandonment, and that's easy. You just leave, right?
I noticed there are an awful lot of conditions that.
For abandonment?
Yes.
Oh, yes.
Are you going to cover any of those briefly or not, or is that just for us to read?
Well, I can talk about it. I was trying not to bore you too much, but thanks. Wait about half an hour, okay? When that coffee is gone,
Get you another one.
Yeah, thanks. I made yours, but I do it too. So when you look at the statute, in order to prove abandonment, you have different options under the definitions. And so one of those is that you have left the child for like 6 months, I believe, with no intention to resume care. So you've basically dropped the child off at grandma and grandpa's and said, see you later. And 6 months, 8 months, whatever have passed, at least 6 months. And you've had you haven't been sending money, you haven't been calling, you've made no efforts that you want to re-engage yourself with this child. We use prison as abandonment. I'm not sure
Yeah, and
how that
that
flies.
was exactly the one that struck me was,
Yeah.
that prison amounted to abandonment.
Mm-hmm. So if you have been incarcerated for a year or more, under the statute, the department is not required to have a treatment plan with you. And a treatment plan is basically the steps that you need to accomplish in order to be reunified with your child. So depending upon what the offense is, because sometimes the offense will be something that is in and of itself an ability to terminate. So if they've sexually abused a child, then you can move for termination. But if it's, say, like forgery or, we don't send people to prison for bad checks, but there would be a lot of bad checks for them to happen. I can't think of the case, unless they just totally violate and get a new offense, right? But say like burglary or something that is, they go in and rob a house and they go to prison for their sentence is 5 years or something. If we get involved in this case and this person is in prison during that case, and it looks like we're not going to be able to reunify with the mother, then we do look at whether or not we're going to use abandonment to terminate on dad. If dad has any interest in parenting is another question, because often in that case, they're more often than not, they're forget it. Although, there is the exception. In my last termination hearing, I didn't have the mother or the father of 2 of the children, there are 3 children, most of them don't have the same dad, by the way. Whatever. I mean, I'm not judging, but usually you're in a room and there's 4 and you got 4 different dads and one mother. I did have one, which was interesting, with one dad and 2 different mothers. It was the first time that happened. But anyway, so in this case, he was from prison. Actually, I had 2 in a row. You were there for both of them, right? My last 2 terminations, I had, one was actually in a halfway house. He didn't want to call it a halfway house. But he had been in and out of prison ever since this child had pretty much been born, like since a year old, and the child was now, I think, 7 or 8. So his role in that child's life was not substantial at all. It did not look like he was going to ever be out long enough to parent, which is another consideration, right? You know, are you going to go back in, and if you've only been out 2 months out of 8, is this really worth, you know, is it good for that child to be placed with someone they don't even know? You know, because at that point, if the person's been in prison for a while, even if they are the biological father or mother, they likely don't have a substantial relationship with that child. The other one actively participated from prison and talked about all the fabulous things he's doing in prison, and he's pretty sure his appeal's going to come through any day, even though his parole date is like 2015, and he's been in prison ever since we've had custody of the children. So the court didn't buy it, and ended up terminating in that case. But that is something that's also considered. If you can also leave your child, like within the first 24 hours or something, I'm not sure exactly what the time frame is, but if you decide just to kind of drop your, like a safe haven law, you don't want to parent this baby, and rather than taking care of it, you're going to give the child up. So there's the turning the child in basically to the department, because you just can't parent and the child's newly born.
So that first scenario you gave of dropping the child off at the grandparents
Yes.
for 6 to 8 months, how do you find out about it? Do the grandparents then complain and want to get rid of the kid?
Well, that's a good question. So sometimes I would say that it would be, sometimes the grandparents, something's happened and their health isn't, you know, going well. Sometimes the parent decides now they want a parent, and then they're trying to come back, and then the grandparents are mad, and so they're calling it in. You know, or I'm trying to think of what else. I'm trying to think if I've had a case that actually is like that. I was just trying to think of an easy example.
Usually a family member is the one
Somebody
you meant.
contacts you.
Yeah, somehow. Well, do you guys know about the child abuse hotline? Have you guys talked about that?
No.
Okay, so there's like an 800 number, and we'll talk about who mandatory reporters are.
We talked about
Yeah.
that.
Okay, so it's anonymous. You'll never know who reported it, unless they're going to voluntarily raise their hand and say, hey, I called that in. But the CPS can't tell anyone under law who reported that information. So you'll get calls in there. So sometimes we don't always know who the reporter is. We can have a pretty good idea. But unless that person's willing to come forward and actually testify and volunteer, basically, or I track them down and say, hey, you know, I need you as a witness. Are you willing to show up? Which is about a 50-50 flip when it comes to family members. It depends upon how mad they are as to whether or not they're willing to actually say something against usually it's their son or their daughter at that point, you know, to help their grandchildren. So.
Going back to my very original question, and you've covered a lot of things I really
You want all of them?
I was actually thinking in terms of termination for prison.
Yeah.
Is there any? Let's say mom and dad are brewing meth in the bathtub, and they both get a 2 or 3 year federal pop, and is that like the kids are gone?
Not necessarily. So I guess it depends upon, like, if mom and pop are brewing meth and the children are in the house, then the kids are more likely to be gone. If mom and pop are brewing meth, but they got a babysitter for the kids, or they dropped them off at grandparents, I know. We'll see. Yes. Rented stuff. These are the things that we talk about, right?
Okay.
So if they took steps to protect their child from being exposed to it, then it's a different situation.
Okay.
If they have family members that are, you know, they've done like a power of attorney to that family member, or they've entered into a guardianship, so while they're gone, they've taken care of their child. It's more the ones where they're getting arrested, the child was there, they have nowhere to place the child, and they're going to prison and kids here, you know, and then those are the ones that we're getting involved in. mostly when we terminate when a person is in prison, it's usually when that person has had no involvement in the child's life, minimal involvement at least, and for whatever reason, the other parent, we weren't able to reunify. They failed their treatment plan and just weren't able to get it together. So we're looking at termination on them because of failed treatment plan, and then we'd be looking, okay, where's this other parent and what are the right status and have they had a relationship? So that's kind of usually when abandoned. We don't just, like if you go to prison, we don't just take your kids away. You know?
Okay, yeah, that was.
Yeah. It's not an automatic,
Yeah.
like you're in prison,
Yeah.
bye-bye kids. That doesn't
We-
happen. Yeah.
That was where I was going with my very, very, very original
Okay.
question.
There are, if you want to know though, under this statute, 41.3.102, there are specific requirements for abandonment, which I did not mention. So if you looked at, unfortunately it's all in alphabetical order, which is pretty handy. So if you look under abandon, or abandonment, it says leaving a child under circumstances that make reasonable belief that the parent does not intend to resume care of the child in the future, willfully surrendering custody for a period of 6 months, and during that period not manifesting to the child or person having physical custody of the child the firm intention to resume physical custody, or parent has been unknown and is unknown for a period of 90 days or voluntarily surrendering. And you might wonder, how can you not know who the dad is, right? Because usually you know who the mom is. Right? We hope you know who the mother is. If you don't know who the mom is, we've got a problem. But we've had cases where we have I think the most I've had is 3, maybe I've had 4. 3 or 4 potential bio dads. And I'm just amazed. I'm doesn't it take 2 days in the month, for this to actually happen? So, but anyway, neither here nor there. I'm not judging, I'm just impressed that we have this selection. So, there are cases too where mom truly doesn't know who dad is. Either she doesn't know or she doesn't want to tell you, right? And you can't force someone to tell you something that they don't want to tell you. We don't torture or waterboard our parents. So, even if we want to. But, sorry. Anyway, I'm losing my train of thought because I'm just going to go on the next one now. Mandatory reporters. So we talked a little bit about this child abuse hotline. So there are certain people that are required by law to report child abuse or neglect. And child abuse or neglect is what we talked about as far as the defined. So we're talking about not just physical abuse or sexual abuse, but substantial risk of, psychological harm, or abandonment. Unfortunately, I'm not sure all the people that are supposed to be reporting and are mandatory reporters quite get that the term is broader than it is. If you talk to someone that does CI, they're going to tell you they get tons of calls in all the time. They don't need any more business. But that being said, I think that sometimes they just think, okay, I have to see a bruise, or I have to know that there's sexual abuse. Is that a question? Are you stretching?
We had a question come up last week about, do you actually have to be performing the duties of a CASA, when you encounter the potential abuse or neglect, and therefore are required because the CASA is a mandatory reporter, or if you just happen to be at the grocery store and observe something that looks like child abuse?
Number 1, so you have to be performing your duties. In order because basically what happens if you fail to report as a mandatory reporter, you're subject to a criminal charge, which is a misdemeanor up to 6 months in jail. Not that you're going to go to jail for 6 months, but no one wants the threat of going to jail for 6 months, right? And then a fine. So it has to be while you're doing your official duties as a CASA that you're required to report. That being said, is there anyone in this room that's here? You're all here because you like kids, right? Or if you don't like them, I don't know, you want to torture them, I'm not sure. But anyway, you're trying to help them, right? So you don't have to be a mandatory reporter to call the hotline. So my advice is that if you see someone wailing on someone in the grocery store, or something, that you call it in anyway. It's an anonymous report. But you're not required to. We're not going to go after you criminally if you haven't called. if you are assigned to a case and you're working as a CASA and you end up seeing something that happens in the home, like you're there and you're talking to the parents and all of a sudden you see something that is completely inappropriate, whether it's just, neglect, like, I don't know, mom's sitting watching TV and completely ignoring the child and the kids too and running around and sticking its hands on the burner or whatever, or, getting smacked across the face and, having some bruising or that
So
kind
no
of stuff.
choice, report that.
Yeah,
'Cause
if
we're-
if
our
you
job.
are correct
Okay.
in your job duties,
I
yes.
assume that if it's in the course of our job duties, that we don't call the hotline, we call whoever's CPS on the case, or you?
I would call both. So you're required to call the hotline.
Oh, you are?
You are
okay.
required.
Even for that, even for performing our duties, we would call the hotline.
Call the hotline
Correct.
rather than whoever's on the case.
I would do both.
Okay.
Do both. But you're required, just because you call the CPS worker, doesn't get you out of the obligation to call to
Okay.
call in the hotline. And I'll tell unfortunately, not everyone understands this. I think in law enforcement, unfortunately, maybe one of them that doesn't quite get it. They think, oh well, I told the CPS worker on the case, so why do I need to call into the hotline? And I'm like, you need to call in the
That's what I
hotline
thought.
because there's record of it. And if for some reason we're 10 years down the road and someone's suing us and there's no record of you calling into the hotline, you're going to be in trouble. And technically, if you don't call in, you could be charged with criminal,
Yeah,
misdemeanor.
the same thing,
Yeah.
because the mandatory reporting then requires use of the hotline.
Correct. So
Okay.
you have to call in. That's how you do the mandatory reporting. I would definitely encourage, if you're working on a case, please don't just think, oh, now I called in the hotline, I was tell the CPS worker. Because sometimes things from the hotline don't get to the CPS worker. Imagine that, right? That's a shocker. That bureaucracy
I
doesn't
expect
always
the
work.
CPS worker would like a heads up anyway.
Yes, they would. Yeah, most definitely. Yeah, that would be a problem. Probably, depending upon how severe the situation is, might be this trial home visit isn't really working very well. So as far as mandatory reporters, we have some obvious ones. Obviously, physician, resident, intern, member of hospital staff. I always love to say, I'm not sure, or wait, hold on. Who's in the medical profession? Anyone?
That one gal is gone tonight. That was a nurse.
Okay, perfect. So, I'm not sure St. Pete's always gets this one. Like, they kind of think, oh, I'll believe the parents' story.